Good afternoon, good morning, hello. My name is Jordan Bentley. I'm one of the attorneys here at McIntyre Elder Law. And I want to start today by addressing one of the questions that I get all the time, whether it's from my friends, family, people who come in to our office for appointments. What is elder law and what is estate planning? Elder law sounds like, law for old people. And that's partly true. But it's also not the full story. What we do as estate planning or elder law attorneys, really, in my opinion, comes down to three main areas of focus. The first one being avoiding guardianship. So you do that by making sure you have powers of attorney in place to act as agents on your behalf. So you never have to go through a guardianship proceeding and no one ever has to become your guardian. The second would be avoiding probate. Probate is the default process by which all of your stuff will pass to your heirs or to other people after you die. It's also the only opportunity for creditors to come and make a claim against your estate and take your stuff. So we want to avoid having our property pass through probate. And third is making sure that you maintain your eligibility or the ability to qualify for some type of benefit like long-term care Medicaid to pay for assisted living or skilled nursing care that you would get in a nursing home or a facility like that. So again, there are three big areas: avoiding guardianship, avoiding probate, and making sure that you can qualify or receive a government benefit to pay for long-term care, which can get very, very expensive if you don't have that benefit. So how do we do that? How do we do those three things? Well, there's a list of documents that we like to call the foundations of estate planning, your foundational documents that I think everyone should have. The first one of those, it's a pair, that would be your powers of attorney. So you have a healthcare power of attorney and a general durable power of attorney, also a financial or legal power of attorney, you might have heard it called. Healthcare power of attorney, very straightforward, very easy to explain. That is a document where you pick someone to act as your agent, as your healthcare power of attorney, and you're giving them the ability, the authorization, the right to make healthcare decisions on your behalf. What might those healthcare decisions be? Well, they can hire and fire doctors. They can, choose different medications or different treatments for you, and they can access your medical records. They can choose what kind of facility you're at. They can remove you from a facility or put you in one. And anything that you could do for yourself in the realm of healthcare, you're giving them the ability or the license to do for you. It's very important that you have that because this person can make those decisions for you when you are unable to. Whether you're recovering from a surgery, whether you have lost capacity temporarily or permanently, whether that be from dementia or Alzheimer's or something like that. Or you could just, be recovering, like I said, from a surgery in a rehab facility and need something done for you that you don't have the physical or mental ability to do in that moment. And that healthcare power of attorney, that agent that you pick, is able to do those things for you, which you can understand could be very, very important if you're, say, recovering from a surgery in a hospital and someone needs to make healthcare decisions for you because you can't. So it's very important that you have that person in place. The other power of attorney that I mentioned was a general durable power of attorney, which a lot of people refer to as a legal or financial power of attorney. It is called a general durable power of attorney, but I like to call it a comprehensive power of attorney. The one that we draft here at our firm for most people is about 20 pages long, and it will cover every different possible scenario that agent will find themselves in on your behalf. It'll give them the right to buy and sell property, to access your bank account, to talk to a lawyer about your estate planning. Anything in the legal, financial, comprehensive professional realm that you need done, that person has the license, the authority, the ability to do for you. This can be very, 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 very important to have. Very important to have because similar to the healthcare power of attorney, this is a person who can act on your behalf when you are unable to. So if you need to talk to a lawyer about possibly qualifying for a benefit like long-term care Medicaid, if you need someone to buy or sell property for you, to manage any of your legal or financial affairs when you're unable to do so. And if you don't have that power of attorney in place, you're stuck. You don't have the legal ability to do that if you've lost capacity or you don't have the physical ability to do it, if you're recovering from a surgery or you're, maybe not very mobile. So it's very, very important that you have both the healthcare power of attorney and the general durable power of attorney in place. And it's even more important that you have them in place before it's too late, right? Because once it's too late, once you lose the ability to sign a legal or financial or healthcare document for yourself, you also can't sign a power of attorney for yourself. So you can't appoint anyone at that point, and you're stuck. And the only thing to be done at that point is a guardianship proceeding, which is not fun, just to put it bluntly. The guardianships are twofold. You have to go to the court and you have to say, hey, this person does not have capacity, does not have the ability to make decisions for themselves. And you get a court document that says that, which is not fun and also not a great thing to have floating around out there, right? Maybe you've temporarily lost capacity, or you have good days and bad days. You don't want a document that says you don't have the ability to make decisions for yourself, out there in a court document. You don't want that. The second part of that guardianship hearing, if it's determined that you do lack capacity, is to appoint a guardian. So you have maybe your child, maybe your spouse, asking the court, hey, pick me, I'm the best person to manage, my wife or my mother's affairs. The court doesn't always pick you. Maybe you have another relative who thinks they do a better job, and now we're fighting as a family to see who should be the guardian. The court can also pick a third party, a lawyer or a financial professional to do that, and really take the control away from you and away from the family. We want to avoid that, one, because they're not fun, as I've said multiple times, and also because they're not guaranteed. You're asking the court to appoint a guardian, and then you're asking the court to pick you. We do those hearings. We do a lot of them. I think we're very good at them, and we're very good at getting the right person appointed guardian, if you are the right person. But we could avoid all of that, the cost of court, the time of court, the stress, the not knowing if you're going to become guardian or not. We can avoid all of that by having a power of attorney named ahead of time, having that agent put in place while we have the capacity to do so that when and if we do lose that capacity, someone that we trust, someone that we picked ourselves, is able to do that for us. They can step in our shoes and do anything that we would want to do ourselves or need to do ourselves. So very important. That's the healthcare power of attorney and the general, durable, comprehensive power of attorney. And that's how you avoid guardianship, and that's how you make sure there's someone in place that can manage your affairs when you can't. So that was the first area I mentioned. The second is going to be making sure that you have a will in place. And a will is going to help you through the probate process if you haven't avoided it. So I said we need to avoid probate. So you do that by naming beneficiaries on your accounts, maybe doing some deed work with your property, like a life estate or ladybird deed. And those things will help your assets pass automatically upon your death. Like, you've probably heard of a pay on death beneficiary on your bank account, or a transfer on death beneficiary on your investment accounts. When the moment that you pass away, those accounts, those assets, that house, if you've set it up correctly, will automatically pass to the person that you picked, the beneficiary that you named. Very good thing, because that property, those assets will now avoid probate, and creditors will have no opportunity. We're talking about hospitals, nursing homes, Medicaid, will have no opportunity, no window in which to put a lien on that property or, make a claim and against your estate and try to recover some of that money that you owe. But it is important to have a will in place. And a will, to put it simply, is a guide through the probate process. It is you saying where you want your stuff to go that does end up in your estate. So we want to avoid anything going to your estate. We want to pass it automatically upon your death. But it's important to have a will in place in case something doesn't pass automatically. Something slips through the cracks, or maybe you have some money coming to you in a lawsuit. Maybe there was a wrongful death lawsuit. Maybe there was a personal injury lawsuit towards the end of your life. Medical malpractice, something like that. And in order to get any of that money, receive those funds, you'd have to open up the estate, because the estate's the one that receives that money. Well, if you open up your estate and you don't have a will, your stuff is going to pass according to the laws of North Carolina, right? It's going to go based on how many kids you have, based on whether you're married or not. It's just going to pass automatically by some rules that some people in Raleigh made up years ago. What's much better than that is to have, again, a will in place, a last will and testament, where you say specifically who's going to get what of your stuff, right? I want to leave half to my son, half to my daughter. I want to leave my son my motorcycle, and then half of everything else to my son and half to my daughter. You can get as specific as you want. You can have as many beneficiaries as you want. You can leave things to the church, your neighbor, your friend, your aunt, your dog, all kinds of stuff. And that's why it's important to have a will. So we want to avoid probate, but if we end up there, if any of our assets, if any of our stuff, right, ends up in our probate estate, you want to have a will where you've named an executor, someone that you trust, similar to your agent under your powers of attorney, to look at that will, take it to the courthouse and then do what you say. Say, hey, here's the will. I'm the executor. I want to pass these assets to who they wanted them to pass to. It's very important to have a will, a last will and testament. So the third area we said was making sure that you can, maintain some kind of ability to qualify for a benefit to pay for your long-term care, right? So nursing home care, skilled nursing care is $10,000 to $15,000 a month, sometimes more, hopefully less, but not often. You can see how that could get very, very, very expensive, very, very fast. So if you have, a couple $100,000, you have a nice pool of assets, right? You're going to pay for that skilled nursing care, that assisted living. You're going to pay for that every month, and your assets are going to deplete, and you're not going to be able to give them or pass them to who you want because they're all going to go to paying for your care. Right? So there's government benefits, such as long-term care Medicaid, that will pay for your skilled nursing care, right? Your income, so your pension, your Social Security, that'll go right to the facility, but then there'll be a gap, right? Because you're not getting $15,000 a month in Social Security and a pension. If you are, that's fantastic. So there's going to be a gap between how much that facility costs and how much your income is. And long-term care Medicaid will pay that entire thing. So you can, not have to spend down or give up all your assets to that facility for your care. And the way we do that is by having an estate plan in place that's flexible, that's maneuverable, that allows you to maintain your ability to qualify, right? Not have assets count against you for Medicaid, but put them in something like a trust, or put them in your spouse's name so they don't count against you, so you can still be under that asset threshold and you can qualify for a benefit, and the government can pay for your long-term care instead of you and your family, right? You don't have to pay, and you can give that stuff to your family rather than wasting it or using it on long-term care. So speaking of long-term care, speaking of that medical end-of-life stuff, the other very important document that we consider a foundational document would be the living will. I know we just talked about wills, so wills and living wills, that can get confusing. A last will and testament is what we talked about, a guide through probate where you say who gets what. A living will is very different, and it's, to be frank, horribly named. What it should be called is my declaration to die a natural death. So if you're, in a hospital, and you're sick and you're incurable, past the point of no return, it is a document, a legally binding document that releases everyone else from liability. It releases everyone else from the stress of making that decision and says, hey, if I'm at this point, if I'm being kept alive by ventilators, artificial nutrition, it's okay to pull the plug, it's okay to let me die. And what that does is, one, for a lot of people, that's an ethical decision or a religious decision, and you have the right to make that, and you should. The second part of it, I've heard, one of my partners here at our law firm, Brett and Begley, say, he doesn't want to wither away. He doesn't want to be in that state. He doesn't want his family, his friends, his loved ones to see him like that. So for him, it's about pride in making that decision for himself before he's too diminished as a person, right? Another great reason why you might want to do it. For me, it comes down to taking that burden or that stress off of my loved ones. I know I wouldn't want to make that decision for someone that I care about. That'd be very stressful. That'd be hard. And I wouldn't want anyone else to have to make that decision for me, right? What if your family disagrees? What if your spouse wants to keep you alive and hope, but your kids are ready to move on, or the other way around? Not only do you prevent them from fighting and disagreeing, but you prevent them, you remove the stress of that decision entirely, and you say, hey, these are my wishes. This is what I wanted. Let's do that. And on the back end of that, what that does is the hospital, the doctors, they're going to follow it because it releases them from liability. You are saying, this is my decision. No one's going to get sued over this. No one's going to get in trouble. This is what I wanted. We need to make this happen. So if you're past the point of no return, if you're not coming back, we're talking about doctors have been looking at you, multiple people have given their opinion. At that point, you have the right to say, hey, it's over, it's done. You go ahead and let me go. It's very important to have that document for the reasons I mentioned, right? Removing the decision from your loved ones, making it for yourself, and as I mentioned, Bretton's opinion, not only are you preventing yourself from getting to a point where you're in his words, withering away, right? But during that time, you're going to incur a lot of medical debt. Keeping you alive is very expensive. So you can remove that as well. You can say, hey, let's stop accumulating debt that my spouse is going to have to pay. Go ahead and pull the plug and let me go. So the foundational documents, again, to cover them would be your powers of attorney, healthcare power of attorney, and general durable power of attorney, which I like to say is comprehensive power of attorney, a last will and testament, the will that most of you are familiar with, a list of who's going to get what of my stuff, and the living will, which is different from the will. It's my desire to die a natural death. If you have those documents in place and you have an open mind about your estate plan and about how to pass your assets through things like a ladybird deed or maybe putting them in a trust, then you're set, right? You have the documents in place as a foundation, and we can maneuver and build on top of that and make sure that people who want to get your stuff get it, and it doesn't just get wasted on long-term care or get claimed by a creditor after you die. Our goal is to do those three things so that you can, leave a legacy behind for your children, pass the assets to who you want to have them. You worked hard for those, right? You care about people. You want to make sure that they get to benefit from your hard work, and that's what we'll help you do. Please don't wait to